Welcome to Inside the Markets with John McLeod. Each program we will bring you insider insights by interviewing the top minds in the market, intriguing local business owners and hobbyists in order to create an insightful, one-stop resource to improve your lifestyle and enhance your education, all provided by the top local professionals in our area. Here today with Kristin Conroy from Conroy and Durant, and thank you for taking the time to listen in and see what's going on here in Southwest Florida. So, Kristin, tell me a little bit about Conroy and Durant.
We are a boutique real estate law firm that has been involved in the Southwest Florida market for over 20 years. My brother started it in the early 90s, I'm going to say. I joined him in 97, and we focus exclusively on real estate related legal matters.
Okay, which is good because that's what we're talking about today.
Perfect.
I love that. It works out really well. I had sent you some questions to kind of prepare for this, and they're kind of fun. What makes you unique and stand out in your profession versus other attorneys that do this?
We have 3 board certified real estate lawyers, the partners. My brother Tom, my partner Mike Durant, and myself are all board certified in real estate law. And it's the fact that the whole firm focuses on real estate. We have some phenomenal paralegals and staff that really understand the contracts, really understand real estate, understand the issues that come up day in and day out, and so we can handle most questions that
How
arise.
common is it to have 3 board certified attorneys in the same office?
I don't know of another one locally.
Okay.
There could be, but I don't know of another one locally that has 3.
What do you do to keep learning and progressing in your industry?
Well, of course, the Florida Bar requires continuing legal education requirements, and so all attorneys do that. As a board certified real estate lawyer, there are additional CLE requirements that have to be at a higher level. So we meet that, and we go to a lot of seminars, and we teach a lot of seminars, and so that helps us stay on top when you're actually having to teach the matters.
Tell me something you're not good at.
Okay, I love gardening.
Okay.
I am a horrible weeder. I'm horrible at weeding my garden.
That's funny.
I start out gung-ho, and then weeds somehow just take over. So I have to find my vegetables in the middle of the weeds.
Nice. Well, welcome to Florida. Everything seems to grow when you don't want it to. Last question before we get into our topic is, you have a choice. You get your room, desk, or car. Which one are you going to clean first?
Room.
Yeah.
Just because I have 2 big dogs that shed a lot, and it needs a lot more attention.
What kind of dogs do you have?
They're lab mixes.
Okay.
Adopted them from Lab Rescue.
Oh, excellent.
They're mutts and crazy and fun and a riot.
Excellent. Very good. Well, I know today we're going to talk about the advantages or disadvantages of different ways to take title in property, whether homesteading or owning in a trust is the right mix. So why don't you go ahead and start things off on that?
Well, what I thought is an interesting topic is homestead is really interesting in the state of Florida, and I think it's more complex than it is in other states.
Okay.
We call it the chameleon of real estate, the chameleon of real estate law. It changes, but there are many different aspects to it. There is the exemption from forced sale by creditors. So for your homestead property, creditors cannot take your homestead.
Okay.
And homestead is up to, if you're in a municipality, it's up to a half acre of contiguous property. If you're outside a municipality, up to 160 acres of contiguous property.
Okay, so that would be the difference between Naples proper and unincorporated Collier County.
Exactly.
Even though it's still referred to as Naples.
Right.
Once you get north of Pine Ridge, you're no longer incorporated. Okay.
Right. So once you're outside the city limits, you can have up to 160 acres protected from forced sale by creditors, and that's judgments don't attach to your homestead property. The exceptions are, of course, a mortgage, taxes and association assessments, and then people who are doing work on your home. Laborers have the
Sure,
construction
mechanics
lien
liens and
rights.
that sort.
Yeah.
Okay. Is there a limit to the value of the property?
No. So that's why a lot of famous people will.
I was going to say, is that why OJ moved here?
Exactly.
Okay.
And there are other famous folks that end up buying here in part for the protection of the asset.
Is that one of the things that when you start getting into the luxury market here in Naples that tends to elevate the pricing more than you would think? Because it seems like there's the property values in Southwest Florida are certainly among the highest in the country, and is that due in part because of the homestead laws?
It definitely could be in part due to that. I mean, obviously it's throughout the state, and we are a unique community, but there are also a lot of folks on the East Coast that take advantage of this homestead benefit as well.
Okay.
So I think it does play in part, increasing the values. But that's definitely a benefit of homestead, and that's a benefit that you don't have to do anything in particular to get that benefit, other than have the present intention of making the property your homestead property. You don't have to file anything. You can file a declaration of domicile, but you don't have to file anything. But courts are going to look at if you're being sued and you're saying, hey, this is my homestead property, it's exempt. You're going to have to show indicia of your intention. So courts are going to look at a whole variety of.
Is that where
indicia.
your license?
Driver's license,
okay.
voter's registration, and so they're going to look at all of these intentions, where you get your tax bills, and if everything points to that being your homestead property, you're going to have that protection.
Okay.
And that's different than another benefit, which is your tax exemption. For homestead property, there's a tax. You get $25,000 off your
valuation,
assessed value for all taxes, and then another $25,000 off for non-school related taxes. So you can have up to $50,000 off your assessed value.
Okay.
And to get that, you do have to apply to a property appraiser's office. And
okay.
and literally, I've had clients ask me, "Can you please, go ahead and file this for me?" And you have to take it in person.
Okay.
You have to bring the deed
right.
and other information showing that this is in fact your homestead property.
Now, obviously, we see a lot of homes owned in trust down here, and even I see a lot of property owned in trust where the people live in the homes year-round. How does that affect homesteading?
Well, you can take title. So to get homestead status on your property, it either has to be in your individual name or in a revocable trust, and you have to bring the revocable trust to the property appraiser's office for the tax exemption and show them that you are the beneficiary of it. So you can either hold it individually or in trust. Where holding it in trust for a homestead gets complicated is that there's yet another constitutional provision relating to homestead that says for a homestead property, it can only be devised to your spouse if you're married.
Okay.
You can't devise it to third parties if you are married and have minor children.
Okay.
If you don't have minor children, you can devise it to your spouse. So there's very particular language in the Constitution that says how your homestead has to be devised. The public policy is basically that they want homestead property to be protected from creditors and to stay within the family, basically.
Okay.
So the difficulty is that people come from another state. They might have a trust that has some, the beneficiary of the trust is another credit shelter trust, and it gets kind of complicated, but they want to protect their assets. Mm-hmm. And sometimes that's held to be not in compliance with the constitutional provisions that provide the homestead property has to go to your spouse and to your minor children.
Okay. What if you are a single individual without a spouse or kids, whether they're minor kids or adult? Is there any sort of snafu that they could be running into owning the property in trust and trying to homestead?
Nope. Then they
Okay.
can hold it in a trust, and they can devise it in a will as they would see fit.
So the individual that's hoping they have a rich uncle somewhere actually has an opportunity with that.
Right.
Okay.
Yeah,
Excellent.
their rich uncle. And so sometimes people will put in a trust that, property goes to a charity. And that's
Okay.
where, again, people can get into trouble, is that can be found to be a devise that is against the Constitution, and the courts will actually have it go to the spouse or the minor children.
Okay.
And another kind of quirk that comes up is yet another constitutional provision that says in order to sell, devise, or mortgage property, your spouse has to join in if you're
Yes.
married on homestead property. So a lot of times we'll be involved in a transaction where title is held in one person's name, and we ask if the person's married, and they say they're married, and then we say, okay, well, we need to have your spouse join in. That can, for the most part, that's not a problem for a lot of people. So even if title is held individually, if they're married and it's their homestead property, they have to have the joinder of their spouse.
Okay.
Sometimes people are involved in a divorce and they say, oh, no, we really, that's not going to work, and we have to go through the process because otherwise it's a void deed.
So in a
Doesn't-
divorce proceeding, let's say it's an ugly divorce, and they're still legally married. At that point, it sounds like both parties need to sign off, even if the arrangement is one is going to get the property. If the divorce has not been settled and is not finalized, both still need to sign off.
Right.
That can create some challenges.
It can create some challenges.
Okay.
Exactly.
When is it not advisable to own property in trust?
To me, the only time is when you are married and it's your homestead property. To me, most real estate lawyers and even probate lawyers will recommend to take your homestead take title to your homestead as husband and wife as an estate by the entirety.
Okay.
And that way, upon the demise of the first party, title automatically transfers at the date of the death of the first party, automatically transfers to the spouse outside of probate. And then at that point, the person can put title in their trust.
Okay.
And then, especially if they don't have any minor children.
Okay. Are there any particular mistakes that you see when taking title that's fairly common?
Well, we have people who want to do estate planning in their deed. And instead of doing a will, they want to take title as husband and wife as to a certain portion of the property, and then 4 children. And that can get very complicated because you never know what's going to happen in the future. You never know if there's going to be a disagreement with one of your children. And all of a sudden you have to go sell the property and you have to get everyone's signatures.
Okay.
Or you want to go to mortgage the property, you want to take an equity line out and you have to get everyone's signatures. So I see sometimes people wanting to put everyone in the family on a deed ends up creating some issues down the road. The other one that comes up is when boyfriend and girlfriend buy property together.
Okay.
That can sometimes be an issue because everything's going along swimmingly at first and then there's a breakup. And you're talking about splitting costs, you're talking about both of you have to agree on a purchase price or a sale
Yep.
price. And so that
It's
sometimes-
it sounds more complicated than if you're married.
yeah.
Okay.
And again, I mean, not that if you're breaking up, if there's a divorce in a marriage, that can still get complicated as well. But it just seems that because they are, two completely separate individuals,
Sure. Okay.
it can definitely get complicated. We've sometimes done what's called a tenancy in common agreement, basically, that says, we understand we own the property together, we're going to share the cost together, but then there might be a buyout provision.
Okay.
If one party wants to remain in the property, they can buy the other party out, and how that process goes. So that's one way to alleviate it if there's boyfriend and girlfriend, and they come up upon issues. Well, okay, I'll buy your interest out, or you buy my interest out.
All right, excellent. Well, Kristin, thank you for the time today. I appreciate
Absolutely.
it. We've been sitting with Kristin Conroy from Conroy and Durant. Her number is at the bottom of the screen if you have any questions. Thank you very much for attending. Appreciate it.
Thank you for joining us for another edition of Inside the Markets with John McLeod. I hope you found this topic interesting. Each show we will bring you intriguing and relevant commentary from the top experts here in our market. If you have suggestions for future topics or would like to be a guest on the show, please email me at johnmcleod@kw.com. That's JONMCLEOD @kw.com.